This bill is a much needed amendment to certain areas of the Election Act. Firstly, the idea of having to consult the presidency and the governors for the provincial elections is in my mind a complete redundancy. Because firstly, we can't afford the majesty of this head of executive office, which is the presidency and the governors who are their extensions. And frankly, there isn't enough majesty to go around because everyone in these seats ends up behaving like a partisan political hack and ends up frustrating the system or ends up validating a redundancy. So as far as the Election Commission being the constitutionally authorized body to decide upon election dates is concerned, I think it's a necessary amendment. However, and I don't think that the oversight of the president was doing any good here. It was, in effect, a ceremonial decision to announce the elections once given advisory by the ECP, and hence I think an unnecessary appendage to the electoral process. So that's the first part of it. The second part is the various forms of disqualifications available under the Constitution for various forms of disqualifying acts committed by people who aspire to be members of National Assembly or are members of National Assembly when they start facing the acts of such disqualification. These are, the Constitution speaks for some disqualifications and doesn't speak for others. So if you commit a crime of a certain variety, you are disqualified from office for 2 years or 5 years, disqualified from running for office for a certain amount of time. However, there was no clarity within the Constitution and the law of what would happen if you were disqualified under 62(1)(f). So the 62(1)(f) is the Sadaqat and Amanat qualifier, that you are sagacious, righteous, Ameen, and it is upon this qualifier that Nawaz Sharif was disqualified when it was found that he was less than sagacious, righteous, and Ameen because he hadn't declared the salary, the unwithdrawn receivable that had become his salary due to him from a company owned by his son. And similarly with Jahangir Tareen, because he hadn't declared a trust which was not his, but he had some form of connection to it. His children were beneficiaries of that trust. So this disqualifier, when it got to the Supreme Court, back when the Supreme Court was in Get Nawaz mode under Saqib Nisar, in a very piety-laced decision authored by Umar Ata Bandial Sahab, who is currently the Chief Justice, it was decided less on the premise of law and much more on the premise of religiosity and piety, that this is the greatest betrayal that can possibly be, and hence the disqualification for this must be life. It's a decision that is frankly absurd, and it should not be upheld. It would not have been upheld had there been an appellatory process, but it was being conducted under the 184(3) suo motu jurisdiction. So it does, in effect, this legislation does then put meat on the bones that was the law before, and it does provide clarity. But as far as the decision itself is concerned with regards to Nawaz Sharif and Jahangir Tareen, those decisions stand and cannot simply be undone by a simple law, and would have to be undone by an appellate process through the Supreme Court Review of Judgments Act or through the Supreme Court Practice and Procedure Act, which are currently up in the air because the Supreme Court is listening to challenges against them. But this would make it easier for those decisions to be overturned, because it would provide a structure to what the Parliament thinks is feasible and what the Parliament thinks is an appropriate amount of censor for an act that is entailed in the Constitution. So it is going one step further, and it is reducing the arbitrariness of these things in their entirety. And the judiciary, if it were to travel upon a compact with the establishment and go out and try to level the playing field as it tried in 2018, for there to be at least a structure to how much they could level. Well, yes, this will benefit everyone that is going to bear the brunt of the judicial acts, because look, if you get to the nub of it, this should not be law in the first place. This vague understanding of sadaqat, amanat, honesty, sagacity, it's an accident waiting to happen, and it's a deliberate accident waiting to happen, where law is crafted in such obtuse terms and it is wielded by a judiciary that has a checkered past of siding with the powers that be. Then you get the results that you get. So yes, everyone benefits when there's structure to it, but ideally it shouldn't have existed in the first place, and the people should These politicians who are disqualified by such weapons sealed within the law should instead face their disqualification and their accountability at the hands of the people, at the hustings, at the polls. But sadly that is not the case, and until that is the case, we will not have a more mature democracy. Well, no, it doesn't mean that, because minusing, as we've seen, if you can take someone out from an electoral cycle, you've effectively minused them. And especially the politicians we have and the age brackets that they're in right now. And the nature, the fluidity and the mercurial nature of our politics as a whole. And if you couldn't imagine, no one could imagine the current political situation even 3 months ago, let alone what could have been imagined before April 2022. So yes, if you take someone out of the playing area for 5 whole years, I think that is, if it isn't a death sentence, it certainly is a very, very long time to be out of politics. So no, it doesn't remove the minus understanding, but it does take one step towards that.